I am calling the Board of Appeals.
This conference will now be recorded.
Good. Okay. To order. The first order of business is for, let's do a voice roll call and state whether or not you can hear the other participants. And I will begin. This is Ronald Crutcher, and I can hear everyone. Mr. Hughes.
This is Josh Hughes. I'm able to hear everyone.
Okay, Mr. Lee.
This is John Lee, and I can hear everyone.
Mr. Adams.
This is Glenn Adams, and I can hear everyone.
Ms. Show.
This is Kenneth Choate, and I can hear everyone.
All right, we have a full quorum, and everyone is in communication. The first order of business is to, if you haven't already, review the minutes. And
Mr. Chairman, a couple of housekeeping things we got to go over before you do the minutes.
okay,
If there is no objection from the Board of Adjustment and Appeals members and subject to Executive Order number 65, let the minutes reflect that the members have determined it is necessary that this meeting be held electronically to protect the health, safety, and welfare of the public due to the COVID-19 pandemic. Let the minutes reflect that the board has made the determination to conduct this meeting electronically. I do want to remind everyone that each vote must be by roll call. Chairman will call your name, at which time you will provide your vote. If you're making a motion or second or asking a question or making comment, please identify yourself. This goes over with staff also. Next order of business is the minutes.
the minutes have been emailed to you. Are there any questions, comments?
Mr. Chairman, this is Glenn Adams, and I'm going to go ahead and throw out a motion to accept the minutes as presented.
The motion has been made. Do I hear a second?
Mr. Chairman, this is Kenneth Choate, and I will second the motion to approve the minutes.
All right, minutes have been, the motion has been made to accept and seconded. Board's vote. We will begin by voting, and I will begin. This is Ronald Crutcher, and I vote for the motion to approve the minutes. Mr. Lee.
This is John Lee, and I vote for the motion to approve the minutes.
Mr. Hughes.
This is Josh Hughes, and I vote to approve the minutes.
Mr. Show.
This is Kenneth Choate, and I vote to approve the minutes.
Mr. Adams.
This is Glenn Adams, and I vote to approve the minutes.
All right, the minutes are approved, and we will move on to the next item. I'll turn it back over to Mr. Cook.
Thank you, Mr. Chairman. I do want to bring to the board's attention that the item B has been pulled. This is the appeal from Carbine and Associates. They have pulled their appeal and have accepted the fact that they owed the fees. The first and only appeal before you today is from Crescent Homes, Tennessee. The appeal concerns Lot 291 in Lockwood Glen subdivision. I would like the minutes reflect that no additional documentation or explanation was submitted by or on behalf of Crescent Homes. The first argument the appellant makes is they have obtained vested rights under the Vested Property Rights Act of 2014. So the lots at issue would not be subject to the impact fee. Private Rights Act provides that should a developer receive preliminary plat approval from the local authority, the development standards in place shall remain the same through the course of the development. For vested rights to attach, the impact fee must be considered development standard or development regulation? And if so, then the impact fee would not be applicable to those developments that receive preliminary plat approval. However, the Vested Property Rights Act is triggered if the impact fee is a development standard, which the Act specifically referenced standards and regulations concern the actual development of the property to include local stormwater requirements, local construction standards for buildings, streets, alleys, curbs, sidewalks, and lot sizes. These all concern the actual development of the property. Impact fee has nothing to do with the development of the property, and in fact, Mr. Chairman, the property can be developed without ever having to pay the impact fee. I do want to ask that should the board find that the impact fee is a development regulation triggering vested property rights, we maintain that the applicant has provided no evidence that it received any approvals from the planning department or planning commission for the property at issue prior to the adoption and implementation of the education impact fee. The second argument appellate makes is that the impact fee is required to be calculated on each subdivision, and the proceeds received from that particular subdivision is required to be used on educational capital projects for that specific development. The Private Act does not require the county to find specific zones to accommodate each subdivision. In fact, the Private Act grants the county's legislative body broad power to implement an impact fee system as they see fit. To support its decision to have a countywide fee, and based on a detailed study submitted supporting the impact and need of expanded or new additional educational facilities, the legislative body determined that a countywide impact fee is needed because of the ever-changing school districts, as well as the fact that development in one area of the county has an effect on schools in another area. I do maintain that there is no support for appellate's argument. There is no requirement for them to create separate subdivision zones as they come for approval. I want to ask if there's any representatives for the appellates on the line. Hearing none, Mr. Chairman, we ask for this appeal denied.
Bobby, this is Joe Horn. Would it also be an accurate statement that we did supply adequate notice to home
Yes.
builders and the public? Thank you.
Yes, I thought I did that. Okay, definitely.
This is John Lee. I'd like to make a motion that we deny the appeal.
Motion's been properly made. Do I hear a second?
Mr. Chairman, this is Kenneth Choate. I'll second the motion to deny the appeal.
Motion's been properly made and seconded. Are there any questions or comments before we vote? Hearing none, we'll call for a roll call vote, beginning with Mr. Lee. If you vote for the motion, you're voting to turn down the appeal. Mr. Lee.
This is John Lee. I vote for the motion.
Mr. Hughes.
This is Josh Hughes. I vote for the motion to deny.
Mr. Adams.
It's Glenn Adams. I vote for the motion to deny.
This is Ronald Crutcher, and I vote for the motion to deny. The votes, go ahead.
Mr. Crutcher, this is Kenneth Choate, and I vote for the motion to deny the appeal.
My mistake. Sorry about that. All right.
That's okay, but
We have voted on it. The vote is unanimous for the appeal, for the motion, which is denied. So the appeal is denied. Is there any other business to come before the board?
We have no further appeals for the board today.
Mr. Chairman, this is Joe Horn. We have one appeal coming up, more behind that said report as well, that we will have to hear before the end of the year. And I've discussed this with Mr. Cook, and we suggested that it probably the best thing, and also to stay away from our standard meeting date, that we would attempt to reconvene this board on Tuesday, December 29th at 7:30 a.m. to hear that appeal. WCTV can provide us coverage as well, which is also a pretty important aspect of this.
I'm sorry, what was that last comment?
Just that also WCTV will be available to cover this meeting and put it on live stream as well. So that seems to be the best day we can work this in. I'm sorry for the inconvenience, but sad to report you guys have been inconvenienced before.
Okay. Then the next meeting of the board will be December the 29th at 7:30 by Zoom. And
Yes, sir.
if there is no other business, this meeting is adjourned.
You know, Joe, this may kind of present a problem for me because I usually start celebrating the new year around the 27th or 28th. And I don't know whether I'll be in a condition to attend this meeting.
Well, let's do it this way, Glenn. I'll come over that morning, we can celebrate together, and maybe between the two of us, we can get on this particular platform.
Yeah, there we go.
Well, as
Merry
long,
Christmas to all, and all stay safe.
all right, Mr. Adams, just make
Yes,
sure you
sir.
are on the phone and not on the video.